call the first case on this morning's docket. That is case number 104092, State of Kansas Appellee v. Melissa Wells Appellant.
Michelle Davis on behalf of the appellant. Mr. Chief Justice, may I please reserve 2 minutes for rebuttal?
2 minutes is granted.
Okay, thank you. There are several issues I'd like to briefly touch upon today. First, the failure to instruct on lesser offenses. This was a felony murder with an underlying felony of child abuse. And it's our contention that the district court erred in failing to instruct on the two reckless crimes, which would be reckless involuntary manslaughter and also reckless murder, and that there was evidence to support that this was a reckless killing. Primarily Ms. Wells' testimony that the child was not breathing and that she ran around in a panic and she tried to make the child throw up, and at some point she grabbed the child and shook the child, and then the officer responds to the house and he finds her hysterical, standing on the porch, and that her reaction would also evidence a lack of an intent to kill here. And I think what the state argues in their brief is that they point to a case. Obviously, this court's decision in Berry changed the analysis on this issue. And what the state cites in its brief is a case called Becker that actually predates Berry, when the standard was you only gave the instruction on lesser if the underlying felony was weak or inconclusive. And in Becker, the court said because the jury had convicted of the underlying felony, we would have to find that the jury had improperly convicted of that in order to instruct on the lesser. And it's our argument that given the change in the law, that case is not doesn't carry a lot of weight. If you look at the Berry case, in the Berry case, the jury had convicted of the underlying felony. It was a high-speed chase, and the underlying felony had been possession of cocaine. And even though the jury had convicted of the underlying felony, in Berry, this court said this jury could still have found that this was a reckless killing. And the court remanded for the court to instruct on lesser. So I don't think that that argument by the state carries weight. Unless there are any other questions about that issue, I'd like to move on to
I just want to make sure I'm clear on what rule you say we're to apply here. Are we to apply the pre-Berry rule? Are we to apply some intermediate rule? Are we to apply the current statute as it's been amended? What exactly is your position?
My position is what I state in my brief, that because this case is on direct appeal at the time of the Berry decision, that Berry applies. And when I bring up pre-Berry law in the Becker case, I'm just simply doing that just to negate the state's argument that the fact that the jury had convicted of the underlying felony
and why
doesn't control this issue. The state says it's a matter of law because the jury convicted of the underlying felony.
Why doesn't the new statute apply?
Well, that's interesting because that argument was not raised in the state's brief. So I did not have an opportunity to do a response brief and raise that argument. So I don't think that argument's properly before this court. The state raised that issue or that argument in a 609 letter, which is not a proper vehicle for presenting an argument to the court. But if I had to answer your question, I would say that the change in the law could not be applied retroactively to Ms. Berry, the change in the statute, because I believe the standard on that is that it would disadvantage her, that the change in the law would be to her disadvantage, because obviously it would take away a substantive right, which is her ability to be convicted of a lesser offense, which would carry a lesser punishment. So if I simply had to respond to the state 609 letter, that would be my response.
And on retrial, let's say you prevail on retrial, is she retried then under the new statute?
Isn't it the law in effect at the time of the commission of the crime, and then this court's interpretation of the law in effect at the time of the commission of the crime? So I would say no. because this court's interpretation of the law in effect at the time of the commission of the crime would mean that Barry would control. Off the top of my head, that would be my response.
I think the original trial happened before the Berry decision.
Right.
So she was actually tried under the pre-Berry rule, which was that she wouldn't get the instruction if there was strong evidence, basically, of the underlying felony. Is it your assertion that there's weak evidence of the underlying felony?
No.
I mean, if you're saying that she gets tried under the law of the case, or the law that existed at the time of the crime, that's pre-Berry.
No, she gets tried under the statutes that exist at the time of the commission of the crime. And this court interpreted that statute in Berry to mean something.
That the previous rule was an error.
The previous court's interpretation of the statute was
That's
an
what I
error.
mean.
So she would get this court's interpretation of the statute that was in effect at the time she committed the crime. And this court's interpretation of that statute is Berry. Okay. So moving on to, I think I want to move on to the prosecutorial misconduct issue. And there's just three, as are in my brief, there's three things I'd like to point to. The prosecutor was very aggressive with the defense expert in terms of his compensation that he received. And in cross-examination, she said, your website says that you find the truth, and don't you do that for a fee? And then in the closing argument, the prosecutor says to the jury, you get to decide the credibility here. You get to decide motivation of witnesses, why they're testifying the way that they are. And she compares the 6 doctors that testified for the state versus the 1 doctor here for the defense. And she says, aren't there at least $3,500 worth of reasons why he is saying this for his client? It's our position that the prosecutor went too far, that she wasn't simply pointing out the fact that the defense was being paid for his work as a motivation for bias, or as a possible point out to the jury that there could be a possible bias here, that she in fact was implying that he was testifying falsely. She didn't say falsely, but that's pretty much, he's testifying, he's saying what he is because his opinion has been bought. He's testifying the way he is because he's being paid.
Where's the line between that and our cases where we have proved that courts or prosecutors or any attorney can refer to the bias of an expert witness because their fees have been paid for by one party?
Yes, and I noticed some of the cases were, for example, he's hired to come here, he's a professional who testifies, he's being paid to come here, he's being paid to come here. And you can test his credibility by that, was one of the comments. But I think there's a couple of problems here. There's no evidence. I think one of the cases I cited in my brief talks about there's no evidence that he's testifying the way he is because he's been paid. So there's a difference there. There's one thing to point out they're being paid. Then there's another to make the link that they're testifying the way they are because they're being paid. Because there's no support for that.
Isn't that a reasonable inference?
Well, no.
I mean, you're never going to get an expert to confess. So yeah, I'm lying. I've made up I've created an opinion that fits my client's case because they're paying me. I mean, I maybe that's happened, but I doubt it.
They're making, I think it's one of the cases, they're making the payment the issue itself. There's a difference in saying that they're pointing out a possible bias and saying that the testimony is bought. He's testifying the way they are only because of the payment, not because this is their opinion. That's the difference.
The statement was something to the effect of $3,500 worth of reasons to testify that BC's death was accidental. Right,
so they're saying they're giving you this testimony for the money. That's the difference, and you don't know that. He could be testifying the way hopefully he's testifying the way he did because he took an oath to tell the truth, and this is his opinion. This is what he believes the evidence in the case shows. And if you say he's testifying the way he is for $3,500, then you're saying there's no truth to what he's saying. There's no basis in the evidence for what he's saying. He's simply saying that because of the money. That's the difference, and it's a difficult line, but it's improper. Because does the prosecutor know this? I mean, do you see a defense attorney standing up and saying to police officers, you're testifying this way because you work for the state and you're going to do anything you can to support, or arguing to a jury, the police officers are only saying this because they have to support the state's case or whatever.
So
You don't, the defense attorney doesn't know that. An attorney doesn't know that they're testifying. You can point out, well, you're an employee of the state, or you work for the state, or you're trying to support the state's case, but you don't know that unless you have somebody admit to that.
So the prosecutor could tell the jury or remind the jury that this witness is a paid witness, and then just that's it. That's stop.
Because that's
and
all
go
you
no
know.
further.
That's all the attorney knows. Anything else, you're just throwing. You're throwing dirt and hoping it's going to stick.
Counsel, what would be the best case you can cite us to support your argument on this issue?
That would be the Ward case, because I do believe that in the Ward case where they said that 2 plus 2, the court didn't say that. The prosecutor said the expert would say 2 plus 2 equals 5 in order to get paid. So I think it's pretty comparable in this case. They're pretty much saying, when she said 2 plus 2 equals 5, that's what this lawyer was pretty much saying. There's $3,500 worth of reasons why he's saying what he's saying. He'll say anything for the money. And then I think this is a prosecutorial misconduct issue, so I just did want to emphasize that this was very prejudicial to the defense, because the defense expert here was the core of the defense case, that there was another explanation for the child's death. Because the question here really wasn't about what happened. There was testimony that the child had fallen down the stairs. There was testimony that the child had been shaken. The issue in this case is, what was the cause of death? Was it this prior trauma and then medical from the prior trauma, or was it the shaking that had damaged the child? So this sort of attack upon the defense expert really substantially weakened the defense case. And are there any other questions about that issue? I'll move on to...
Not on that issue. I have a question about your response to the state's argument on the instruction on 455 evidence.
Okay.
They essentially say that this wasn't really about prior acts of the defendant at all. It was just about observable injuries to the child. What's your response to that?
You know, it was interesting. The prosecutor asked Ms. Wells, let me see if I can find that. She said to Ms. Wells on cross, isn't it true that when you were the primary caregiver, Brooklyn was covered in bruises? And when you did not have access to the child anymore, she was fine. I mean, they're talking about months here, from September through December. Their whole case was she was the primary caregiver and this child always had bruises. So I don't know how you can say that these aren't, that this was not, and the state filed a 455 motion, and the judge granted it, saying, can we bring in evidence of prior injuries to the child? When they said it in their 6455 motion, the judge ruled on that and said, yes, you can. Then they just didn't include it in the limiting instruction.
But do we ignore the plain language of the statute that speaks to specific acts of civil wrongs?
As opposed to...
Well, I mean, the fact that she had bruises wasn't evidence of a specific act of a civil wrong.
Well, it was evidence of a crime, because there was a testimony about the child was in church, and the doctor was there, said, this looks suspicious to me. So, I mean, there was evidence of it. There's a battery, perhaps, or a child abuse, and that's why the grandparents are taking the pictures, because they think it's wrong, that this is an inflicted trauma upon the child. So, I mean, that's certainly evidence of a crime. Mr. Chief Justice, I wanted to briefly mention one more issue. Could I perhaps get a little bit of my rebuttal time back, maybe a minute?
That would be fine. How much time would you like?
Just a minute would be great. Thank you. On the alternative means, I just quickly want to cover, there are two means here. It's our contention there's two means on the felony murder, child abuse or attempted child abuse. Now, I know this court has said, in the context of a DUI, operating or attempt to operate are not alternative means. In aggravated intimidation of a witness, dissuading or attempting to dissuade are not alternative means, but those are both within the statute. In this case, it's our contention, and as you would if you say felony murder by ag robbery or felony murder by ag burglary. Those are alternative means of the commission of felony murder. It's our argument that an attempt, because it's a separate crime, that fits that paradigm of two separate crimes that could constitute the felony murder, and that's what makes them alternative means, as opposed to the case law where the attempt is like the DUI and the ag intimidation, where the attempt is within the language of the statute itself. That would conclude my comments.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Chris Elslager on behalf of the state. And I will try to take the issues, I think, in the reverse order, addressing the one that she most recently touched on. I would just point out that I don't think attempt is an alternative means. It's not a separate crime. It's actually a lesser included offense of the underlying felony. So this case, as I put in the brief, is not an alternative means case. It's not a sufficiency of the evidence case. At most, it's similar to Bailey. It's a jury instructional error where you have some extra language in the jury instruction because attempt was never presented to the jury. They weren't instructed on attempt. They were only instructed on the one single alternative of the commission of the child abuse, the felony. They found the defendant guilty beyond a reasonable doubt of that felony, and so there simply isn't an alternative means issue here. The 455 evidence, as I think the court has obviously picked up on, there was no 455 evidence here because there was no evidence presented of any prior crime or civil wrong by the defendant. It was simply evidence of observed injuries to the child by other people. At no time did anyone testify that they saw the defendant harm the child or anything like that. There was no evidence of any conduct on her part. So it really does not fall within the ambit of 455.
What about that one question that Ms. Davis pointed out where the Wells was asked about, then asked to explain why there was bruising when she was the caregiver and not at other points in time?
Well, that doesn't introduce evidence of a prior crime or civil wrong.
It's just inferring it.
Possibly, but I mean, she's asking about observed injuries, and I think that it's just part and parcel of the case itself. And what they in their brief, what they challenged was the testimony of the grandfather, Mr. Corsetto, and that was what I responded to in the brief. They challenged that as being 455 evidence, and it's not. It's just observed injuries to the child. So this does not fall within the ambit of 6455. The prosecutorial misconduct claim, this case is not like Ward. Ward, the prosecutor said that this person would tell you they're paid, and they would tell you 2 + 2 = 5 if they were paid to do so, which implies they're paid to commit perjury. This case is almost right on point with State v. Broyles, where the prosecutor said in closing, "Now, what possible reason would the defense expert have for coming to testify?" Well, you heard him. He said he's being paid $1,000 a day to come and testify in this case. All right, this court heard that argument, said that's okay. That's within the latitude allowed. There's plenty of case law that says it's okay to point out a possible bias for an expert to testify, and that the fee that they receive is a possible bias. I would also point out that...
Can you comment, though, on the distinction that we were discussing with appellant's counsel, which is that there's a difference between commenting that there may be a motivation for this expert to testify because this expert's being paid, and commenting that I can give you 3,500 reasons why this expert is here. That's saying this expert is lying because they're being paid to lie. And there is a distinction to be made there, isn't there?
But
that's a credibility comment, certainly.
That wasn't what was said, though. I mean, in Ward...
What else? I mean, what else could it... It's kind of a snarky comment, 3,500 reasons. I mean, what else does that mean?
It certainly implies that there may be a bias or a motivation for coming to testify, which this court has said is fair game. And it's just like in Broyles, where the prosecutor said he's being paid $1,000 a day to come in here and testify. This court said that was okay. And I think the other thing to remember is that this particular comment came in rebuttal after the defense got up and said, now what possible reason would Dr. Young have to come in here and testify and say, no, this didn't happen, something along those lines. So I think that's important to also remember that this wasn't a pre-planned script by the prosecutor. This was in rebuttal to the defense saying, hey, my guy's got no reason to come in and tell you just what we want you to hear. I mean, they kind of opened the door to this.
Well, we've recently said that's not a grounds for a
you
prosecutor making a
you
statement.
said it doesn't foreclose, it doesn't just kind of give carte blanche, but you said it's still a factor to consider. And I think certainly it is a factor to consider, especially when you look at the Broyles case. I don't see how this is not on point with Broyles. It's nothing like Ward. In Ward, the prosecutor explicitly said, this person is going to lie to you. This person would tell you 2 + 2 = 5 if he was paid to do so. Here, the prosecutor just said, in response to the defense saying, hey, what reason would he have to come in here and testify like this? The prosecutor said, well, he's testified he had 3,500 reasons to come in here and testify like that.
I thought the prosecutor said, I can give you $3,500 worth of reasons.
Yeah, I don't know.
That's different. That's the prosecutor saying, I can tell you why he testified the way he did, because he was paid $3,500.
How is that different from Broyles, where the prosecutor said essentially
I don't
the
know
same
if
thing?
it is different. I'm asking you if we shouldn't be making a distinction between a comment about a motivation to testify and a comment that indicates the witness is lying because he's being paid to lie.
Well, I think if you made the distinction here, you would be overturning a lot of case law that says mentioning how much the expert gets paid is fair game. I mean, there's years and years of case law that says you can say that. And, in the context of prosecutorial misconduct claim, it would be, I think, wrong to find the prosecutor committing misconduct in that case when you have all these years of case law saying that's okay. And now, if you were to suddenly move the goalpost on the prosecutor, I think that would be unfair to the state, and I think it would be wrong. We have case law that says you can say that. And she did not go beyond the bounds of what the case law says.
But you can't say that the expert gave an incorrect or inaccurate or a wrong opinion because of the payment, because that's what Ward is saying.
Yes, you cannot explicitly say the expert is paid to lie or commit perjury. But you can point out that, hey, this guy's getting paid a lot of money to be here. And so that is something the jury can consider in determining his credibility versus the credibility of other witnesses, the other experts who are also getting paid to be here, which I think was probably pointed out.
Counsel?
Yes.
By the same token, the defense counsel on closing argument, recognizing that closing argument time is precious and you might not want to spend time to do this, but a defense counsel could stand up and say, members of the jury, I need to explain to you the way this works. The state has an array of witnesses who are employed by the state who come in here and testify against the defense. And the only way that the defendant can combat that testimony when there's an expert issue is to hire an expert. I mean, they could kind of head some of this off at the pass in their argument, correct? That would be a proper argument for the defense, right?
I think so.
Okay.
And then if there are no further questions on that issue, move to the issue of the lesser included offense instructions. And as I submitted in the 609 letter, I think this issue has been superseded by the amendments to the statute, which says there are no lesser included offenses.
And if we disagree with you on the applicability of the new statute, how does this work on a retrial?
I think on a retrial, the statute in place would be in effect. It's a procedural statute.
And which interpretation of that statute?
I think you have to apply the statute as it reads right now, because it's not.
I understand your argument, but let's say we disagree with you on the applicability of the current statute. Let's say we accept that portion of your opponent's argument. I'm trying to give you a hypothetical here, so bear with me. Let's say we accept that portion of your opponent's argument, that is that new amendment cannot be applied because it's substantive. Okay, let's just accept that as.
For the sake of argument, I will accept that.
That's the part that you don't like, and we got that. I'm just asking you to accept it for purposes of argument. So then when it goes back, if it's to be tried under the statute as it existed pre-amendment, do we apply the interpretation applied to that statute prior to the Berry case, which was the interpretation applied at the time of the crime, or do we apply the interpretation of Berry?
Well, I think that if you're going to be consistent, if you're going to say the statute doesn't apply to the retrial, then neither would Berry. It would go back to the law at the time of of her trial. At the time of her trial, she was not entitled to a...
One is a statutory interpretation, and one is an amendment. Doesn't one maybe raise ex post facto concerns that the other does not? Or is it all the same?
I think in this case it's the same because it deals with a criminal procedure issue, not substantive rights. The amendment to the statute doesn't take away any right that she had at the time
You're
of trial.
still making an argument on the point I'm asking you to take as a given. I want you to focus on the interpretations of the statute that were pre-Berry and as of Berry.
The problem is you couldn't...
And that's not ex post facto.
I mean,
That's not disadvantaging the defense.
If
That
you
would,
were-
if anything, advantage the defense.
I mean, I guess if you were to reverse on the grounds of Berry, it would not make a whole lot of sense for you to reverse on the grounds of Berry and then tell the district court that you should apply the pre-Berry standard, although I think that's what it should be, but you can't get there logically. So I guess if you don't buy my argument that the statute as amended applies and you decide you have to apply Berry, then you have to apply Berry. I mean, I don't see how you could reverse on the grounds of Berry and yet send it back
To be tried on the
to be tried on the
pre-Berry
pre-Berry. That just doesn't make sense. I don't like that, and I think that's wrong. But if you were to disagree with me on the application of the statute, I don't see any logical way how I could get to where I want to be. So
Okay.
so let's don't go there.
Please, so let's not go
but
there.
if
That's why you're hanging on
there
so
is a-
tenaciously to your side of the argument.
There is another. I do have another peg to hang my hat on if you disagree with my interpretation of the application of the statute, and that's what they're asking for. Lesser included instructions on reckless conduct, on reckless secondary murder and involuntary manslaughter, and the court has said that lesser included offense instructions are only required when the evidence would reasonably support that lesser included instruction. And I would submit to you that the evidence here does not support any kind of reckless conduct. The evidence presented by the state was that this was all intentional. This was intentional child abuse. There was never any allegation of reckless conduct. The defense said there was no conduct on her part. It was all a terrible accident. The kid fell down some stairs or another kid jumped on her.
But wasn't there some testimony that she was trying to clear their airway or whatever and may have shaken too hard, or that wouldn't that be reckless conduct?
No, because one of the aspects of reckless conduct is a manifestation of indifference to human life. So if she and ignoring that danger. So if she was trying to save the girl's life, that does not indicate a knowledge of danger and indifference to human life. So it does not fit reckless conduct. And so if you look at the evidence here, the evidence was this is intentional conduct. There was no evidence of recklessness presented to the jury. So it wouldn't support the lesser included offense instructions that she's asking for.
Explain to me why, if I am charged with one crime and then at the point of jury instructions would have the opportunity to be convicted of a lesser crime, that isn't a substantive issue in terms of applying the new statute and your argument that it's only remedial? To me, that seems pretty substantive.
I'm sorry, I didn't follow. You have to ask again. I didn't follow your question.
If I'm charged with a crime A, but at the point of jury instructions I have the possibility of being convicted of a lesser crime, that seems pretty substantive to me. Why is it only remedial?
Okay, I see what you're saying. Well, I suggest that it's remedial because all it does is return the law to the way it was at the time of her trial. At the time of her trial, she didn't have that right. She didn't have the option for those lesser included offenses. That only came about by an interpretation, a case ruling by this court, which this court said is applicable to all cases that are currently pending. So I would submit that if that's the case, then when the legislatively kind of overrules that decision, that's also applicable to all cases now pending because it's just doing the same thing. It's just basically taking away that decision, returning things back to the way they were at the time of trial.
But it didn't do exactly that.
It
didn't do exactly that. There are two different rules. I mean, it did away with lesser included period when you charge felony murder. And that's different from the pre-Berry.
It is, but not in this particular case because in this particular case...
The effect is the same.
The effect is the same. And I would just point out that when you look at allegations of ex post facto loss, there's four things to look at. Does it criminalize action that was previously lawful? The answer is no. Does it aggravate her crime? No. Does it increase her penalty? No. It doesn't do any of that, and it doesn't lessen the quantum of evidence required to convict. So it is not an ex post facto law.
So that establishes it's not a constitutional violation, but we still have the general rule that we only apply substantive statutes prospectively and not.
I still think it's just simply a matter of procedure. It's no different than the decision in Berry. And it simply returns, in this case, it simply returns the defendant back to the position that she was in at the time of trial. It takes no right away from her that she had at the time of trial. And if there are no further questions or no questions on any other issues, that concludes my argument, and I would ask the court to affirm.
Any more questions? Thank you, counsel. You reserved 1 minute for rebuttal.
I'll talk fast. The only problem with the state's argument on that is that at the time of trial, the case law says includes, it's not final till you go through the direct appeal. So, and I might be saying that a little bit shorthand, but I said it in my brief, that that's why in Berry this court said that this rule applies to all cases that are pending on direct appeal.
But the statute doesn't.
I'm sorry?
The statute doesn't. It was passed when this case was on appeal also.
Right, but that's different.
I understand your argument.
Different rules,
Right.
different rules. So to try to say the case law just doesn't support the state's argument. I don't know if I've said that well, but the cites are in my brief about why the Berry rule applies to all cases on direct appeal. And the logic behind that doesn't support the state's claim that she only has the rights that were given to her at trial. No, it doesn't stop there. It goes all the way through. That would conclude my comments.
You have 5 seconds left. You sure you don't want to use it all?
Well, everybody have a good day. Thank you very much.
Thank you, counsel. Thank you both for the arguments this morning. Court will take this matter under advisement.